Hello everyone, I'm Dr. Kalpana. Today in this lecture, we are going to discuss the prospectus in Indian company law. Prospectus is a very important document for the purpose of investors. So this presentation will explore the critical aspects of prospectus under Companies Act 2013 in India. We will explore its definition, legal provisions, mandatory contents, various types, which are important to know. There are many kinds of prospectus according to the company's profile. Serious implications of any misrepresentation. Understanding these facets is crucial for law students and legal professionals navigating the complexities of corporate finance and regulatory compliance in Indian legal landscape. So now coming to the meaning, what is the meaning of prospectus? As per Section 2, Subclause 70 of Companies Act 2013, a prospectus means any document described or issued as prospectus and includes any notice, circular, advertisement, or other document inviting offers from public for the subscription or purchase of any securities of a body corporate. It is a fundamental document for public investment, strictly regulated to ensure transparency, and investor protection is a prime object behind keeping this provision in Companies Act. So a key characteristic is its mandatory filing with Registrar of Company ROC prior to its issuance, a requirement that applies exclusively to public companies. What are the legal provisions which govern prospectus? So Section 23, Public Offer and Private Placement. This section outlines the conditions and procedures for companies to invite public to subscribe to their securities and distinguishing it from private placement. Section 26, Matters to be stated in prospectus. So a cornerstone provision, it details the exhaustive list of information that must be disclosed in prospectus to ensure full transparency for potential investors. So that is a very important section of Companies Act 2013. Section 27, variation in terms of contracts. This provision addresses the limitations on altering the terms of contracts mentioned in prospectus, safeguarding investors' expectations and commitments. Section 34 to 36, civil and criminal liability, which is a very, very important provision and section to keep in mind. Section 34 to, there are three sections. So these sections collectively establish a severe penalties for misstatement, holding accountable individuals and entities responsible for issuing a misleading prospectus or any information contained in it. Section 35, civil liability for misstatement, specifically focuses on rights of subscribers to claim damages if they have incurred losses due to misstatements in prospectus, providing a crucial recourse for affected investors. And now coming to the contents of prospectus, that is Section 26 of Companies Act 2013. What should be the contents of prospectus? So first is company's details, mandatory disclosure of company's name, registered office, and comprehensive corporate structure. Secondly, risk factors, a crucial section highlighting potential risk associated with investment, ensuring informed decision making a prospective investor. Thirdly, financial information. So inclusion of audited financial statement for the past 5 years, providing a historical overview of company's financial health. Fourth, object of the issue. So clear articulation of how funds raised through the issue will be utilized, ensuring transparency in resource allocation. Next, directors and promoters. Detailed information about the directors and promoters, establishing accountability and trust. Minimum subscription required. Specification of minimum amount of capital that must be subscribed for the issue to be successful, protecting investors from underfunded projects. Underwriting and commissions. So detail regarding any underwriting arrangements, commissions paid, ensuring full transparency in financial transaction. Another point to be noted that pending litigation, that is very important if a company or any corporate house is engaged in any litigation. So that disclosure in prospectus is a mandate so that investor may know what kind of issues or litigations a company is facing. Disclosure of any ongoing legal dispute that could potentially impact company's financial position, health, or operation. So that is required to be disclosed honestly in prospectus. For example, if a company intends to raise 100 crore to establish a solar plant in Gujarat, its prospectus must meticulously detail all relevant facts, including potential risk arising from policy changes, the current status of land acquisition, an estimated return on investment. This level of detail is vital for investors to assess the viability and risk of the project accurately. So now coming to kinds of prospectus, there are many kinds of prospectus. First, we are dealing with red herring prospectus. So what is the definition and purpose of this prospectus? A red herring prospectus is issued before finalization of price and the exact number of shares being offered. It is predominantly used in book building process, common in initial public offerings, that is popularly called in short IPOs, to gauge market demand and determine the offer price. It does include complete particulars of security offered, distinguishing it from final prospectus. So what are the key characteristics of red herring prospectus? So in bullet, precedes price and share quantity determination, aids in price discovery through book building mechanism, lacks full details of offer as implied by its red herring name. So notable example in India market was Zomato Limited issuing a red herring prospectus prior to its highly anticipated IPO. This allowed the company to test investor interest and arrive at an optional share price based on demand, ultimately leading to a successful public offering. Red herring prospectus plays a crucial role in modern capital market transactions by enabling a flexible and demand-driven approach to the public issue. I believe red herring prospectus example you would be able to easily remember because Zomato is something which has become the part of our life. Second number is shelf prospectus. So a shelf prospectus is a single prospectus issued by financial institutions or banks that allows them to make multiple issue of securities over a specified period without needing to issue a new prospectus for each offering. This significantly streamlines the fundraising process for entities with frequent capital requirements. So one thing is to remember here, shelf prospectus is usually used by financial institutions like banks and NBFCs. Key advantages of shelf prospectus: reduces administrative burden for repeated issues, offers flexibility in timing market entries, cost effective for entities with continuous funding needs. Regulatory framework, typically a shelf prospectus is valid for certain period, often for a year, and supplementary information must be filed with registrar of company before each subsequent issue within that period. For instance, State Bank of India, a major financial institution, which is the biggest national bank, might issue a shelf prospectus for 5,000 crore valid for 1 year. This enables SBI to raise funds through various debt equity instrument multiple times during the year without exhaustive process of filing a new full prospectus each time. This mechanism is particularly beneficial for large institutions that frequently access the capital markets. That is the purpose of this prospectus. Third one is abridged prospectus. Concise summary. Abridged prospectus serves as compact summary of main prospectus containing all essential disclosures mandated by law. Mandatory attachment. It is legally required to be attached to every application from the public issue, ensuring that potential investors must have immediate access to critical information. Key information highlighted, its primary purpose is to highlight crucial detail as company's financial performance, risk factors, and objective of the issue without overwhelming the investor with full document. So the abridged prospectus acts as gatekeeper, ensuring that even if an investor does not read the full prospectus, they are still provided with most vital information necessary to make an informed decision. This regulatory measure is designed to enhance investors' protection by making key disclosures readily accessible and digestible. It balances the need for comprehensive information with practical consideration of readability and ease of access for general public interested in subscribing to the securities. Deemed prospectus. Company allots securities. A company directly allots its securities to an intermediary such as an underwriting firm or financial institution. Intermediary offers to public. This intermediary then offers these securities to general public through their own offer document. So regulatory scrutiny applies. So consequently, all legal provisions and liabilities applicable to formal prospectus, including those for misstatement, apply to deemed prospectus. So offer document is deemed prospectus under Section 25 of Companies Act 2013. This offer document issued by intermediaries legally treated as prospectus. So a significant case demonstrating this principle in SEBI versus Kunnam Kulam Paper Mills Limited, where document issued by financial institution for offering shares to the public was legally recognized as prospectus. This ruling underscores the regulatory intent to ensure that all documents inviting public subscriptions, regardless of who issues them, adhere to the same standards of disclosure and accountability as formal prospectus. So thus, this prevents companies from bypassing strict prospectus regulation by routing their offerings through intermediaries. Now coming to a very, very significant aspect of prospectus, if there is any misrepresentation which can mislead the subscribers, if it is found in prospectus, what are the liabilities of the companies and what can be the consequences? Section 34, criminal liability for untrue statement, which is not true and company knows about it. This section imposes severe criminal liability on any person who authorizes the issue of prospectus containing statements that are untrue, false, misleading. The intent behind such statements or omission of material facts can lead to prosecution. This is powerful deterrent against deceptive practices. Section 35 provides civil liability for misstatement. This provision allows any person who has subscribed to securities on faith of misleading prospectus to claim damages from those responsible. The key is providing that misstatement induced the investor to enter into contract, leading to financial loss. This offers a direct remedy for aggrieved investors. So, misrepresentation in prospectus is defined as false statement of material fact that induces a party to enter into contract. It can also occur through the omission of material facts, making the statements providing misleading in their context. Companies Act 2013 provides robust mechanism to hold directors, promoters, and other authorizing parties accountable for such misrepresentations, reinforcing investor confidence in capital market. There are some landmark judgments on misrepresentation. Peake versus Garney, 1873, is a 19th century judgment. In this seminal case, directors of companies were held liable for deceit because prospectus failed to disclose companies' substantial liabilities, making the otherwise true statement misleading. The court emphasized that prospectus must contain not only what is true, but also material facts that would influence an investor's decision. New Brunswick versus Canada Railway Company versus Muggeridge. This case established a foundational principle: company directors owe a stringent duty to ensure that all material facts are disclosed truthfully and completely in the prospectus. The judgment underscored that prospectus is primary document through which public is invited to subscribe for shares, and therefore it must be free from ambiguity or suppression of truth. These landmark judgments from English common law have profoundly influenced Indian company law, forming the bedrock of principles regarding full disclosure and accountability in prospectus. They highlight that directors have fiduciary duty towards investors to present an accurate and comprehensive picture of the company's financial health and prospectus, ensuring that investors are not misled by either commissions or omissions. Consequences of misrepresentation: recession of contract. Investors misled by prospectus can apply to the court to have their contract for subscription of shares rescinded, meaning the contract is set aside if never adjusted. Damages for deceit, or negligence. Affected investors can sue for damages, seeking monetary compensation for losses incurred due to misrepresentation, whether intentional or unintentional. Fines and imprisonment. Those found guilty of misrepresentation may face significant fines and imprisonment under various sections of Companies Act, particularly Section 447 relating to fraud, potentially under Indian Penal Code. Now it is BNS. The legal ramifications for misrepresentation in prospectus are stringent, reflecting the Indian legislature's commitment to protecting investors, maintaining the integrity of capital markets. These consequences serve as powerful deterrent, compelling companies and their officers exercise utmost diligence, honesty in preparing, issuing prospectus. The penalties are designed to ensure that The document which forms the basis of public trust and investment is unimpeachable, unimpeachable and in its truthfulness and completeness. With this, I would end here. Happy learning. Thank you so much.